Is OceanGate expeditions going to face consequences, real consequences for the Titan implosion? I mean, that's the question that's on everyone's mind after the submarine disappearance that took the internet by storm and claimed the lives of 5 people. Well, guess what? It wouldn't be the first time OceanGate was sued. Hey, you know me, I'm America's attorney, and I like to break down lawsuits and current events for my 20,000 and counting friends. So lawyer up, subscribe, and let's break down the 2018 lawsuit about issues in the quality and safety of the Titan's materials and examine the possibilities for a potential lawsuit now. Let's jump in. One of the first interesting facts about the 2018 lawsuit is that OceanGate was actually the one to make the first move in court. After ex-employee David Lockridge filed an OSHA complaint for allegedly being fired in retaliation for being a whistleblower, well, OceanGate filed a lawsuit for breach of contract, misappropriation of trade secrets, and more. What whistle did Lockridge blow exactly? Well, the one that claimed that OceanGate was using materials that could only sustain a third of the pressure that they were attempting to dive into. The one that claimed that OceanGate refused to take his advice to conduct the appropriate tests to check the safety of the submarine. And the one that claimed that he was fired after submitting an official report to create a record of the issue. Yeah, that's pretty serious whistle to blow. This OSHA complaint led to a lawsuit against Lockridge and his wife, which then led to a counterclaim against OceanGate for wrongful termination by Lockridge. Now, this is not uncommon. Some employers reflexively, and I would argue abusively, turn OSHA complaints, Department of Labor complaints, any sort of government contact by an employee or even a former employee as an excuse to retaliate against the would-be whistleblower. Now, usually they're hoping to drown the employee in the expense and frustration of ever-consuming litigation. And as you might imagine, those retaliatory or hit-back lawsuits are usually bogus, but that doesn't mean that they aren't effective. Some people don't have the stomach or the patience or the money or the stamina to be tied up in litigation for years. But in the end, those lawsuits are usually not over millions and millions of dollars. Now, don't get me wrong, the whistleblower and wrongful termination allegations are very serious, but as much as I would like to delve into those allegations, they are not as pertinent to the issue that's engaged social media and us right now. No, the reason this prior case is so noteworthy is that it creates a history for OceanGate of ignoring safety issues, allegedly, with the Titan submarine. According to both of those prior lawsuits, the issues pertained to the hull of the Titan. Lockridge's counterclaim states that he expressed a need for non-destructive testing of the hull. Well, he says he was told that it wasn't possible and that the Titan would use an acoustic monitoring system. Well, the problem with this, according to Lockridge, is that this type of acoustic analysis would only show when a component is just about to fail, often milliseconds before an implosion, and it wouldn't detect any existing flaws prior to putting pressure on the hull. Lockridge believed it would be absolutely useless in the case of failure. And as the world learned just 1 week ago, his muffled voice, he might have been saying exactly the right things, exactly what OceanGate needed to hear. Once Lockridge submitted his report, a meeting was quickly put together the next day. Now, the particulars of the meeting differ depending on whose lawsuit you're reading. If you read the OceanGate filing, well, they say that Lockridge refused to listen to OceanGate's experts. According to OceanGate's lead engineer, the acoustic monitoring was better suited to detect any safety issues. Lockridge refused to accept OceanGate's decision to stick to acoustic monitoring and stated that he wouldn't authorize man test of the Titan, and so he was let go. Now let's take a look at what we learned about this meeting from Lockridge's perspective. The former director of marine operations claimed he discovered during the meeting that the viewport that had been commissioned was only built to withstand a pressure of 1,300 meters. As I'm sure most of you already know, the Titan's mission was intended to go down to 4,000 meters of water. Now, according to Lockridge, OceanGate refused to pay for a viewport that would withstand the proper amount of pressure. Once everything was said and done at this meeting, Lockridge was given just 10 minutes to leave the premises for good. Now, this dispute was settled in the same year that it was filed. My guess is that Lockridge was paid some money for being fired and he had to go away. Hard to say. But Lockridge, if you are out there, please let us know what happened. Let's move on to the present day. Now, it's not going to surprise anyone that the passengers of the Titan would have been made to sign a lengthy waiver that mentioned the word death multiple times. Well, I've said it on this channel before, and I'll say it again right now. Waivers aren't always bulletproof pieces of paper. Based on extenuating circumstances, they can be waived. That's right, you heard me right. The waivers can be waived. Well, or at least ignored. Now, here are two ways. Number one, if the case can be made of gross negligence or reckless indifference or even some sort of malice, there are jurisdictions that will say, while yes, you can waive regular negligence, you cannot waive a worse level of negligence which borders on recklessness. So that is a possibility here. The second instance in which the waiver is possibly not effective is when there is a potential claim against a company that is not a party to the waiver. For example, if there's a company called XYZ Oxygen Tanks, and during the course of litigation or investigation, it's revealed that the cause of the malfunction in the Titan was due to an oxygen tank explosion. Well, then the families of the departed may be able to effectively sue the tank company, just bypassing the waiver that they signed in favor of OceanGate. Of course, it's not always that simple. It can be hard or even impossible to discover what caused the failure and the deaths. And also, it might just take years. It's also possible for OceanGate's waiver to cover its vendor partners if the contract is written that way. Or perhaps the project is vertically integrated and there is really no one else to sue except OceanGate. It's definitely too murky to say what's going to happen at this point, but the takeaway is that the waiver is not always an effective waiver. Let's bet on this fact right here together. There will be lawsuits, plural, about this mess. But let's assume that there's a workaround and the survivor family members are able to sue. Well, what can they sue for? What can they get? To answer this question, we have to go back to 1920. Not a joke. Back in the day when all boats were wooden and had sails. Oh wait, hold on. It was 1920. Not all boats were wooden back then. But prior to 1920, if you were an American killed by the negligence of other Americans more than 3 miles from the shore of our country, AKA on the high seas, you couldn't sue anyone, couldn't recover any money. The ocean was just a great place to be dangerously negligent. But in 1920, Congress passed the Death on the High Seas Act, and when the act applies to a particular incident, it is the party's exclusive remedy for wrongful death claims, and it preempts any additional claims for wrongful death or pre-death pain and suffering under state law or general maritime law. Now, the Death on the High Seas Act does not necessarily prevent the beneficiaries from making claims based on their own pain and suffering if they personally witnessed the incident that caused the death. Now, no one was witnessing this, but because of what we saw on social media, some of us were aware of what was happening. However, the US Navy later reported that no, in fact, they probably died in an implosion hours before all of us became aware of what was happening. Now, we don't talk a lot about maritime law on this channel, but from time to time, it does appear as an issue that concerns us. In fact, the last time I remember talking about maritime law was during the Darrell Brooks murder trial when he thought he could use maritime law as a defense to murder, and I did make a lot of fun of him. So, if you are under the Death on the High Seas Act, how much can you sue for? Damages under the Act are generally limited to fair compensation for the pecuniary loss sustained by the individual for whose benefit the action is brought. Recoverable amounts are calculated based on the financial benefits that the survivors might reasonably be expected to have derived from the decedent had his life not been terminated, or really, the amount of money that the victim would have contributed to the lawsuit plaintiffs if he had not died. Damages would therefore be calculated based on the decedent's age, earning potential, overall health, and the amount of contribution made to the surviving relatives' lives prior to death. This is a grim sort of math. As of right now, no lawsuits have been filed, but I would not be surprised at all if more than one lawyer has been contacted. The families of these victims absolutely deserve justice. Do you agree? I know social media had a field day with the memes of this tragic event, so there are people out there that don't. But let me know your pro se opinion down below in the comments after you lawyer up and subscribe. And hey, I'll be back soon with more videos like this, so stick around. See ya.